Okay, I'm Erin Somerville, Callum High School, going over Incorporation. So the guiding question today is about who the Bill of Rights applies to. So far we've discussed how the Bill of Rights isn't exactly a list of your liberties and your rights, but rather it's a list of things that the government cannot do in order to protect your liberty. So the language of the Bill of Rights limits the federal government. And the question then, of course, is, well, then do the states have to abide by that list? What I want to do is refresh your memory on this term, judicial review. It's the power of a court to determine what's fair, what's constitutional. And when I say the constitutionality of governmental action, that means any part of government, any level of government, the Supreme Court can determine if the Constitution is being adhered to. So in trying to figure out the rules between the federal and state government, we often go to the court, and that's going to be the case here as well. Now, judicial review is not explicitly in the Constitution. We know that it was established in 1803 in the case of Marbury versus Madison. But for all of our history since 1803, we have understood this to be a fundamental principle, that the power of the court, particularly the Supreme Court, we talk about Supreme Court cases in this course, determines what is fair. They are the referees, and the Constitution is their rule book. So the Bill of Rights, we know that it's a list of your rights and your freedoms, protected by limiting the government. And the government in particular here is the federal government. So if you look at the First Amendment, Congress shall make no law respecting an establishment of religion. That is the wall that separates church and state. It doesn't say you have religious freedom, but you derive your religious freedom by limiting the government. And if there were questions around which government the Bill of Rights deals with, 1833 case of Barron v. Baltimore answers that question. And in that case, the Supreme Court ruled that states are not limited by the Bill of Rights. And that is a document, originally desired by the Anti-Federalists, a document that was meant to limit the federal government in order to protect the people's rights and states' rights. So we know today that that just simply isn't the case. And incorporation refers to that slow process. And we're going to kind of nail down what that process is. So the Bill of Rights, it's a list of your rights and your freedoms, and it limits the federal government. Well, that was an 1833 case. Then the Civil War was fought. And clearly a number of Americans' rights were not secure, and liberties did not exist. And so in the Reconstruction era, 13 amendments were passed. And these were amendments that were going to help reconstruct American society to be more egalitarian and to recover from the institution of slavery. So the first of the Reconstruction amendments is the 13th Amendment, which abolishes slavery. That is not the end, though, in reconstructing a more egalitarian society. There would be a need to make sure that those newly freed slaves aren't relegated to second or third class citizenship. So the 14th Amendment grants citizenship, making sure that those newly freed people are protected as citizens. And then finally, the 15th Amendment, black suffrage, provides the right to vote for all men, no matter their race. So those three amendments are rolled out right after the Civil War as guidelines for reconstructing a more egalitarian society. Today, why I bring this up is we're going to look at the 14th Amendment, because the 14th Amendment, the first section, is pivotal in making sure that states do follow the Bill of Rights so as to protect your rights. So that the Bill of Rights is not some list that is not... so that the Bill of Rights is something that actually exists for you no matter what state you live in. Okay, so you might want to pause it to copy this down. All persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So here we have a statement in Section 1 that says states shall not have laws that go against citizens' privileges or immunities. The no state part is a direct response to the fact that the Bill of Rights does not limit states. This part, in a sense, can be seen as a way to overturn Barron v. Baltimore, but it wouldn't. It wouldn't, but this is the beginning of it. Then I have circled here privileges or immunities. So, tricky here is pinning down what are your privileges and immunities. Millions of people around the world would love to have American citizenship. What are the privileges or immunities Americans have? And there's no long list given in the 14th Amendment. Privileges or immunities, this is abstract. We don't have a clear list of this. Now, we do have a clear list of the Bill of Rights. Had the 14th Amendment made it clear that states could not abridge the Bill of Rights, then this might effectively overturn Barron v. Baltimore and make it very clear that the Bill of Rights applies to the states. But it was worded with this ambiguity, with this vagueness. So who is the authority on understanding the Constitution? The Supreme Court. And that's why we started with judicial review. So it's going to come down to the Supreme Court explaining to us, case by case, what a privilege or immunity might be for an American citizen. Then I have circled here due process of law. I want to reread this part. Nor shall any state deprive any person of life, liberty, or property without due process of law. That should sound familiar. Life, liberty, property, we know that's Lockean thought, but this should sound familiar from the Constitution. Where do we see a due process clause? The Fifth Amendment. Why the duplicity? You know, the Constitution is a rather short document, and ratifying an amendment is very difficult. So why the redundancy? What we need to do is look for the nuance that distinguishes the due process clause of the Fifth Amendment and the due process clause of the 14th Amendment. And here the nuance comes down to no state shall deprive anyone of life, liberty, or property without due process of law. Because according to Barron v. Baltimore, that in the Fifth Amendment only limits the federal government, that the federal government would have to provide due process in order to take your life, liberty, or property. With the Barron v. Baltimore reading, you could assume then that states might deprive you of your life, liberty, or property without due process, since states weren't bound by the Fifth Amendment. So this is a huge clause, the due process clause. It's going to be one that the Supreme Court refers back to over and over again in the process of incorporation. And finally, you should circle the equal protection of the laws. I'm not going to go over this a tremendous amount today, but this is the clause that the Supreme Court most often uses when dealing with civil rights. And we're going to talk about civil liberties and civil rights. But those two lines really are the basis for all civil liberties and civil rights cases in the 20th century. Okay. So here is incorporation. It's the process, which means it takes time. Slowly overturns Barron v. Baltimore case by case. Now, why does it have to go slowly? It's because in each case, the Supreme Court identifies a privilege that you have as a citizen, and says that no state shall deprive you of that, shall abridge those rights. Another way to define incorporation, I have two here. Nationalizes the Bill of Rights, or applying the Bill of Rights to the states. I prefer the second one. But the idea is that your rights to be protected from unreasonable searches and seizures, your right to not self-incriminate, your right to counsel, all of these rights in the Bill of Rights, until incorporation happens, they're not really your rights in a state court. If you found yourself in a federal court dealing with any sort of federal law, then the federal government is required to follow the Bill of Rights in your criminal procedures. But if you found yourself in a state court, you would not necessarily have those protections. State courts were not necessarily obligated to ensure that you had a speedy and public trial. State courts were not necessarily needing to ensure that you had counsel. And the First Amendment, religious freedom, that was your freedom from a religion put on you by the federal government. But it would take a case to clarify that your state couldn't impose a religion on you, or your state couldn't persecute you for your religious beliefs. So incorporation is very slow. Now, the key to making it happen when you read a Supreme Court opinion that says a right has been incorporated and therefore is nationalized, it's always done by the 14th Amendment's Due Process Clause. When I said it's slow, I should have added at that time that it is selective, meaning not all parts of the Bill of Rights have been applied to the states. The 2nd, the 3rd, and the 7th are amendments that have not been applied to the states. For a variety of reasons. There has to be someone who takes it to the court, and then the court has to accept it. And then some of these don't make sense. The 3rd Amendment is about quartering. That doesn't come up these days, so there's not a need to incorporate it. And finally, the 10th Amendment would just make no sense to incorporate. The 10th Amendment is also known as the States' Rights Amendment, and it makes no sense to nationalize the States' Rights Amendment. Okay, so that's the first part, and the rest of the video will be on the next clip.